He's been on bail for 18 months. He's in Northern Ireland, so...
All rise!
Judgment in the appeal, Louca and a German judicial authority, a criminal appeal from Her Majesty's High Court of Justice.
Mr. Louca is a Cypriot national resident in the United Kingdom. His extradition is sought by the Office of the Public Prosecutor of Bielefeld in Germany under an European Arrest Warrant for 6 offences of tax evasion. 2 previous European Arrest Warrants had been issued by the German prosecutor, each resulting in Mr. Louca's arrest, but each of them was withdrawn because of minor technicalities. The current European Arrest Warrant refers to the domestic German Arrest Warrant, but not to the previous withdrawn European Arrest Warrants. Mr. Louca argued that it was unlawful to extradite him under a European Arrest Warrant which did not refer to all the previous European Arrest Warrants. The Supreme Court holds that when a European Arrest Warrant is issued by the authorities of one member state for execution in another, it must include a reference to the domestic warrant upon which the European Arrest Warrant is based, but it need not include references to any other European arrest warrant which may have been issued on the basis of the domestic warrant. The appeal is therefore dismissed.
Judgment in the appeal, be a child.
I will invite Lord Kerr to deliver the judgment of the court.
At the conclusion of the hearing, this court allowed the appellant's appeal and indicated that it would provide reasons for that decision at a later date. The judgment that is handed down today contains those reasons. In short summary, they are these. H is a 3-year-old child whose parents separated before his birth. From the date of his birth until very recently, H has lived with his maternal grandmother, GB. In May 2008, his father, RJB, applied for a residence order in respect of H. His application was refused. In making their decision, the justices noted that they had not found compelling reasons to disrupt the continuity of care that GB provided H. RJB appealed the justice's decision. That appeal was successful in the High Court, the judge finding that the justices had been plainly wrong in making the residence order in favour of GB. The order of the High Court was appealed by GB to the Court of Appeal, and the Court of Appeal dismissed the appeal. This court concluded that the justice's decision was not plainly wrong. They had recognised that H's welfare was the paramount consideration and had carefully evaluated the evidence before them, correctly weighing up the various competing factors. All consideration of the importance of parenthood in private law disputes about residence must be firmly rooted in an examination of what is in the child's best interests. That is the paramount consideration. It is only as a contributor to the child's welfare that parenthood assumes any significance. Any discussion of a child's right to be brought up by its natural parents is misplaced. The only consideration for the court is the child's welfare. There was reason to believe that if H's bond with GB were broken, his current stability would be threatened. And in deciding where H's best interests lay, the justices were therefore right to give significant weight to maintaining the status quo in H's living arrangements.
The court will now adjourn.